Hello, everybody. It's Colleen again, head of marketing at Ketch, and we're back with another episode of the Privacy Huddle. A little different this time because we are sitting in a quiet corner in UCLA for the California Lawyers Association Annual Privacy Summit. And I've heard two of my favorite Privacy Huddle guests, Celine and Max. Welcome, guys.
Hi.
Thanks for having me again.
Thanks for having me and letting me sit in for one of your normal guests.
Celine, you know we love you.
I know, and I love you too. Yeah.
Well, it's such a pleasure to be here with these two. It's been a packed 2 days at the California Lawyers Association Annual Privacy Summit. We thought we'd take a quick break to just talk about issues that have been top of mind. Celine, let's start with you. What's the vibe been?
Serious, I think. People are really starting to dive deeper into some of the real things that are coming up in the enforcement actions. We're talking about, the fact that enforcement is really ramping up. Every year you have more regulators at the regulator table. And then obviously the fact that we've had quite a few enforcement actions. Stacey Schinzer spoke with a couple. And I think people are really starting to realize, or a lot of people who are here are amazing privacy professionals, but really thinking about the deep and very detailed things they need to be thinking about.
Max, have you picked up the same vibe? What's your take on the last 2 days?
Definitely, I sense this, a little bit of panic. I think the most interesting thing that I learned, or at least I saw a little bit of a tone shift during the regulator panel, was around vendor accountability. I think most of the people that we speak to, it's a precarious and lonely disposition to be holding the bag as the company-owned privacy. But for the first time ever, it was really obvious that the enforcement folks are not just thinking about brands and their accountability, but vendors and how they participate in the ecosystem as well.
Yeah, and what was really interesting is hearing all the chatter behind that from people saying there's a real issue here and it needs to be addressed. When we look at the last enforcement actions, brands relied on vendors and there were issues. There's a lot of chatter around that.
No doubt. And a lot of the holy conversations have been around what the U.S. regulators are focused on, and is there a CMP that can meet these requirements? Is there something out there that can do it? Max, in our work at Ketch, we talk to a lot of companies that are using other privacy vendors. There's a couple big legacy players that everybody's very well aware of in the CMP space and the privacy tech space. They're often coming to Ketch saying, what's different? How do you guys compare? What do you think is the biggest difference between some of these legacy platforms that are, let's be honest, coming up in a lot of these enforcement actions and something like Ketch?
To me, I think it's claims versus capability. It's one of the things that I'm most frustrated by in the software game in general is you're going to have salespeople and product people, engineers, whomever, make outlandish claims about the capabilities of the product. And the stakes are a little higher in this particular arena of software. One of the things that I'm most frustrated by is you'll go into a meeting and you'll evoke or demonstrate some capability and they'll say, yeah, the other vendor, they say that too. Now, you talk to the companies that have used that other vendor and they'll come to you and say, yeah, actually it didn't work at all. I had to write all the code to make it happen, or I've been using it and it's actually never worked. And what's the difference with Ketch? Well, they just showed you it actually works. But it's a very, very hard leap for them to make after being burned for 7+ years with other vendors.
I'll add one thing there because I think there's something we talked about that's really important is that when you're looking for that vendor, you really want to be thinking about what you can actually do, but also the record-keeping obligations. That's something that not everybody is doing. And as we ramp up in enforcement and plaintiffs litigation, by the way, you're going to be asked for your number of opt-outs you've received, that kind of thing. It's really very important to make sure your vendor is telling you exactly what they can do.
It's interesting, the record keeping, there's a cute little hack you'll see a lot of CMPs implement, which, they're only storing consent in the browser. And of course, from a cost to serve perspective, it's a very, very easy and efficient way to do this if you were only setting up to build, a cookie method. But I think you made the comment earlier, this isn't a GDPR transpose into the US for opt-out of sale. It's much more intricate, it's much more difficult to do record keeping, but I know you had some other opinions on how do you implement consent management in the context of U.S. privacy, which still seems not to be understood?
I have a real issue with that as a former regulator where I was tasked with enforcing the California law. And the California law is very clear that you have to give the consumer the ability to opt out of sales and sharing. And that is not the same as opting in to certain tools or software on your device. That is a very different proposition because there's a whole thing that goes on the back end. And so I think it's very frustrating to see basically a repurposing of tools that were created early on and that are now being thrust on companies. Often unknowingly, they think that they're complying. And that's a real problem because not all companies have 40 people on their global privacy team. Some have 0. And so when you're implementing a tool, especially when you're a smaller company, you really need to think about, am I being just given some kind of plugin that's not adapted to what I need to do?
Max, I think you should double down on that for folks watching from an educational perspective. Other CMPs, you're saying collect the opt-out signal, they store it in the browser, usually, and that's not enough.
Frequently, yeah. I mean, there are a lot of failure modes. One is where you store the consent. That has implications on the auditability of it, right? If you only store it at the choice someone makes on the browser that they have custody over, if someone in your former chair were to say, "Can you tell me what's going on?" Of course you can, because you don't have a copy of it. That's one failure mode. Another failure mode is just in the architecture of the storage for the consent. It's not that every CMP doesn't store it, it's that in the way you store it, it has to be readily fetchable. So if you have to make a phone call to your account executive to collate all the information about an individual for the purposes of a complaint, is operationally inefficient and takes a lot of time. So there's architecture decisions that you can make in the building of these products that lend themselves to use cases like that. And that's the kind of discernment that you need to have when you're in the RFP process. If you approach this problem from, I just need a cookie banner, you're going to get exactly that. And I think that's the lesson learned. This is not a cookie banner problem.
No, cookie banners aren't required in the United States. We have them because of SIPA litigation. That's a different story. But your opt-out model for California and other states, it should be very clear. This idea of just taking something that worked in another jurisdiction with a completely different requirement is really kind of mind-boggling to me. And the last thing, of course, is enforcement is really ramping up. We're seeing letters, inquiries all the time. These are regulators who know what they're doing. They're smart. They have bigger teams, more technologists. So you need to be able to tell your story,
Absolutely. This conference has certainly stood out to me as one of the first where not only are we talking so much about recent enforcement, but we're talking about what tech is available. I think we got time to tackle maybe one more issue. Celine, I know you attended a really interesting session today about the Delete Act.
Yeah.
What should folks know?
I think this is really important. The Delete Act is basically the data broker law in California, but it has the drop mechanism, basically a deletion obligation for data brokers. Data brokers are very broadly defined, and the potential penalties come August 1st, when the drop mechanism goes into place, are really potentially very high. Now, one thing that's really interesting is that we always think of a data broker, your typical data broker reselling information. They are going to need to be able to implement the API and make sure that they can honor the drop mechanism. But more companies are going to be data brokers, so they're going to have to think about that. And one of the questions that I thought was really thoughtful from you guys was, when are we going to get to see this information? Because when you have a CMP that's doing this right, you really want to be able to layer the different obligations, whether it's opting out, deletion, whatever, in a kind of a seamless, frictionless way. So I don't have the answer to that. Interestingly, it's going to be the developer documentation, essentially, will be in the data broker's account. So what's really interesting about the agency is that they kept all of the registration materials behind a wall. So I can't go and see what the questions are for data brokers, and you have to have your account approved. Liz Allen just specifically called that out. So I'm hoping that those materials come out soon so that tools like Ketch can actually help you. So I think that's going to be an interesting area. The data broker fever is really going to spread to other states.
I appreciate that. Thank you.
No, sure.
I'm serious. It's one of those things where, there's a new requirement that comes out and, brains are scrambling and how am I going to comply with it? But they depend on a vendor who I don't give much think time either.
No, and I think it's important thing that the agency's working on it. I know that they're making updates, and I think they were mentioning April as kind of a deadline to have all that information about the API. So hopefully that's the case. And then August 1st is really the date that people need to be thinking about.
Got it. Well, thank you both for joining me on this episode. Always a pleasure.
Thank you for having me.
Absolutely. Folks, thanks for joining us as always. Any questions, drop them in the comments and we'll tackle it on the next episode.